Yes, good evening to everybody. Welcome to the Law of Thought class, and I am dealing about the vicarious liability. And yesterday that I started it, and this class that I would like to deal with the decided cases in various aspect. Yes, anyone can unmute and read what I posted on the screen, so that you are with me and I am with you. Both are traveling the same boat and reach to the destination. Yes, hurry up. Anyone can unmute and read what I posted on the screen.
Good evening. Vicarious liability. Is he an employee? Organization test, control test, multiple test. Was the tort committed in the course of the employment? What is a frolic of his own? An unauthorized act at an authorized time. Professor Dr. M.S. Hussain.
What is the word that you could not understand in this? I repeat, what is the word that you could not understand on the screen? Answer. Anyone?
Frolic.
Yes.
Sir,
Frolic
voice break అవుతుంది
means
sir.
it is a of the whims and fancy deviation is called frolic. Whims and fancy way of going for the long run or for the own purpose is called the frolics. So that is actually the frolics meaning. Now let us see that is a
Okay, sir.
principal and agent. The relationship is there. Next relationship. If you know it, you tell me. If you don't know it, say pass. For the vicarious liability, there should be at least some relationship should be there. Number one, principal
Master
and
and
agent.
servants.
Master and servant, or employer and employee. Next,
Part, partners.
partner and other partners, father and child. Are you getting me? Some relationship should be there. Then we can say there is a
Yes,
vicarious
sir. Yes,
liability.
sir.
Okay, the mute. Sai Krishna, mute. Danny, mute. Yes, mute. When I ask at the time that you can see, many of people did not mute it because I am getting the sound. Just mute it. When you want to speak at the time, you can speak. Okay? Yeah. Now let us come to the point. Principal and agent, how it can be worked over there. I told you this vicarious liability is based on the two maxims. What are they? What are they? I repeat the question. Vicarious liability,
Respondent superior.
respondent superior, that is the one maxim. Next maxim. Sir,
Qui facet person.
Q facet, parhelium facet per se.
Okay,
Q
sir.
facet, parhelium facet per se. Remembering is nothing but reading, and reading. Reading, recitation, and review. That is the only the way where you can remember the things. So based on the two maxims, here I put it over there. Q facet, parhelium facet per se. The equivalent is he who does through the others does himself. Or we can say also the act of an agent is the act of a principal. Doesn't matter. Even the principal did not work over there. The act was done by the agent, but still the principal is held liable for the act of activities of the agent. So wrong by the servant's fraudulent act. And this is a landmark case law. If you want to cite this case law, you are supposed to cite this case law because it's a landmark case law, or we can say the classical case law. The case law name is Lloyd versus Grace Smith and Company. I repeat, Lloyd versus Grace Smith and Company. So Mrs. Lloyd, she's who owned two cottages, two houses, but was not satisfied with the income therefrom, because in one cottage she is living, in one cottage she has given the rent. Whatever the rent she is getting, it is not up to the mark to her to lead a good life. So she approached to the Grace Smith and Company. It is a firm of solicitors. Is the firm of solicitors. Of course, in England, there will be solicitors are there, but in India, there is no solicitors. We will say it is advocate. Or in other words, we can say vakil or pleader or whatever it may be. So firms, corporate firms, she approached over there to increase the amount of for his livelihood. So to consult them about the matter of her property, so the managing clerk of the company, so one of the managing clerk, is one of the employee there of this Grace Smith and Company. So advised her, you better you sell the two cottages and invest in the stock exchange. Investment, mutual fund or tulip or any other money back policy or any other thing, you can invest it in the capital market, and there the shares are more and you will get the more dividend, and thus you are increase your amount. So well and good. She was asked to sign the two documents. So the managing clerk told that, okay, you sign these documents, and later on we will sell this property, and whatever the amount will come, we will invest in the dividends and shares. Okay. Of course, dividends means you will get the amount. When you purchase the shares, you will get the dividends. But which were supposed to be the sale deed. So they signed on the sale deed, but in fact, it is not a sale deed. It is a gift deed. In his own name, he did it. So the document got signed were gift deeds in the name of the managing clerk himself, but she told her that it is a sale deed, and we will sell this property. Whatever the amount we will get, we will invest it. But he made the gift deed on his own name, and she signed on it. Okay. He then disposed the property. Who the managing clerk disposed the property and misappropriated the proceeds. So he had acted solely for this personal benefit and without the knowledge of his principal. So where he did all this transaction? Where he did all this transaction? In his office of the solicitor. What is the name of the office? What is the name of the office? Baktullara, mute, unmute and give me the answer.
Smith and Company.
Grace Smith and Company's office, the managing clerk is working over there, and all the activities he did it in his office only. It was held that since the agent was acting in the course of the employment, in the course of the apparent or ostensible authority, and the principal was liable for the fraud. Even though the principal did not have any touch with this lady, and even the principal did not have any knowledge that he is making such a transaction, and he is making a gift deed instead of a sale deed. So it is amount to vicarious liability is applicable over there whenever the employee means agent did fraudulently. Is it clear? Say yes.
Yes, sir. Yes, sir.
And the illustration we read
Yes, sir.
that yesterday. If A goes to the bank and deposits the check with the C, the employee of the bank and C fraudulently transfer the amount of his wife's account here for the fraudulent act was C, then the bank will be liable. Because why the bank will be liable? Can you tell me here? Why the bank is liable? Can you tell me here?
Because A goes to a bank.
Every transaction has taken place in the bank itself.
Bank itself.
But the agent, he did it for his own sake, he changed the account. But hence the bank is held liable. And this case we already discussed yesterday. State Bank of India versus
Shyamadevi.
versus నేను వర్సెస్ అని గమ్మునుంటే అర్థం ఏంటిదంటే
Shyamadevi.
Shama Devi.
yes అది అర్థం. You have to give the reply.
State Bank of India versus Shama Devi.
Very good. I appreciate. Now you tell me what happened in this case, la?
Shall I read, sir?
What happened in this case, la? What are the facts of the case, la? We discussed yesterday. Okay. Now I'll read it. The plaintiff's husband gives some amount and checks to his friend, and who was an employee in the defendant bank. For being deposited in the plaintiff's account, no proper receipt of the deposit was obtained. The bank employees misappropriated the amount. It was held by the Supreme Court that the employee, when he committed the fraud, was not acting in the scope of the banks. You can write in your own words, need not to reproduce the same thing. Now you tell me. Anyone? Sir, I'm Telugu medium, sir. Please, sir. No. If you feel like shy, you never learn. Are you getting me? Say yes.
Sir.
Yes, sir.
Sir, in this case, State Bank of India is not held liable.
Yes, regarding one line, regarding the facts of the case, the plaintiff's husband gave some amount and checks to his friend to deposit in the bank. Where? In the street, neighbor, where this fellow is staying over there. But he misappropriated it. And she filed a case, or a plaintiff filed a case. But they say State Bank is not held liable because the transaction did not take place in the bank. So it is not in the course of the employment he committed such an offense. Who? Employee. Of whom? State Bank of India. What are the essential things? The plaintiff, the defendant should have to commit the offense in the course of the employment. That is a very important factor. Is it clear?
Yes, sir.
Very good.
Yes,
Very
sir.
good.
Yes, sir.
Yes, sir.
You write only one line or two line, doesn't matter, in your own words. Even though we don't see the spelling mistake, we don't see the grammar, we don't see the sentence structure. Just we say, oh, this man is having the idea. Okay, he will learn the grammar later, no matter, but he knows the sense. Here, there is no, in the course of the employment, the fraud is committed over there. Hence, the State Bank of India is not liable under vicarious liability. Okay. Next case law is Armrod versus Crossville Motor Service Limited. Can anyone unmute and read this case law? Not in chorus, only. But I want the new voice because same people are reading. No, I don't like. Somebody should have to read it. Danny, you read so many times.
Sir, shall I read?
Yes, other people should read. Okay, read, Danny, read.
Okay, sir. Armor versus Crossville Motor Service Limited. The owner of the car asked his friend to drive his car. While the car was being so driven by the friend, it collided with the bus. The owner of the car was held liable.
Yes, vicarious liability will come into the picture. Why? The owner of the car requested his friend to drive his car, means with the permission of the owner of the car, and he requested his friend to drive the car. Well, the car was being so driven by the friend, it is collided with a bus. So, whether the friend time being is an employee or not, doesn't matter. But he is time being is an employee at the time when the accident took place. So, what is the relationship here? Employer and employee. Are you
సార్ ఆ
following me?
ఓనర్ కి హెల్త్ బాగాలేకుండా నడపన అని ఉండొచ్చు కదా సార్
Yes, even that also comes under there because with the permission of the owner, he asked somebody to drive it, and provided that fellow should have the driving license.
ఎస్
Yes, doesn't matter. Vicarious liability will be applicable over their owner. But the car is stolen, or without the knowledge of the owner, the car is driven away and met with an accident. At that instance, and the owner doesn't know that the car was stolen, but later he came to know the car was stolen, but he gave the application a complaint in the police station. Owner is not held liable. Owner is not held liable. But the victim doesn't see whether the owner is there or taken the permission, not taken the permission. You cannot supposed to keep the four-wheeler or two-wheeler on the road unless until
Caution is
It is a
given.
parking.
unless until the vehicle should be insured.
ఓకే ద వెహికల్ షుడ్ బి ఇన్షూర్డ్
Mandatory third party insurance.
మై ఇన్సూరెన్స్ హాస్ ల్యాబ్డ్ 1 year ago సార్
No, please do it. Just go to the Any agent will commit. Don't worry. You need not go the same agent. Even a showroom, you can go to the showroom and he will do it. Or in online you can do it also. I
Okay,
think there
sir.
is some facility is there. Yes, but many people are there. Those who are sitting like a pawn shop, they will do it. Especially you go to the petrol station, the bunk injection, there will be the sir insurance చేయబడును అక్కడ రాసి ఉంటది. So here the owner only has given the permission. At that instance, vicarious liability will come into the picture. Now let us see the Trilok Singh versus Kailash Bharti. While the owner of the motorcycle was outside the country, his younger brother took the motorcycle without his knowledge or permission and caused the accident. It was held that the younger brother could not be deemed to be the agent of the owner of the motorcycle, and the latter could not be vicariously liable for the accident. Vinnara? Without the knowledge of the owner, if somebody has taken your vehicle and you met with an accident, at that instance, there is no vicarious liability would be there. మరి ఎవరు సార్ దెబ్బతిన్న వాళ్ళకి ఎవరిస్తారు సార్? ఇందాకనే చెప్పాను, ఎవరు ఇస్తారండి? ఎవరిస్తారండి పైసలు?
Insurance company.
Will pay it. Later on, the insurance company will step into the shoe of somebody else and who is the wrongdoer, then will claim the amount from him. That is a different issue. But first and foremost, who has to come to the rescue? Insurance company should have to rescue to the scheme. Depending upon the comprehensive insurance or depending upon the third-party insurance. Third-party insurance, only the victim will get it. In the comprehensive insurance, 360 degrees you will get it. Car, people are traveling in the car damage, everyone will be covered over there in the comprehensive insurance. But the premium is heavy premium would be there for the comprehensive insurance, less premium would be there in the
Third
party
party
insurance. ఇప్పుడు నాకు చెప్పండి సార్, ఒక విషయం అడుగుతా, మీకు 50 రూపాయలు ఇప్పుడే ఇచ్చేస్తారు గూగుల్ పేలో కొడతా మీరు చెప్పిన వాళ్ళకు. A person who is well expert in calculating the premium or ascertaining the premium, and he well versed in the statistics, mathematics and accountancy principle, that person is called
Chartered accountant. Chartered accountant.
No. Chartered account is well and good in the returns, liabilities and assets. 50 రూపాయలు నేను ఉట్టిగా పెట్టలేదండి, నాకు తెలుసు. ఏమంటారండి ఆ మనిషిని? ఇప్పుడు కట్టు చూపెడతాను. యాక్చువరీ అంటారు. ఏమంటారు? చదవండి ఇప్పుడు. రీడ్.
An actuary is a business professional who deals with the measurement and management of risk and uncertainty.
One, a person who is well versed in fixing the premium and is called actuary. అదే మళ్ళీ యాక్చువరీ అనుకుంటే నేను ఈ విధంగా యాస్టువరీ అన్నాను అనుకోండి, ఎంటైర్లీ చేంజ్ అయితే పోతుంది. ఎస్టువరీ అన్నాను అనుకోండి, ఇదైపోతుంది. ఏది? The tidal mouth of a large river where the tide meets with the stream, దాన్ని మౌత్ ని ఎస్టువరీ అంటారు. అక్కడ ESTUARY, ఎస్టువరీ. Because a river meets with the sea, the mouth is called estuary. ESTUARY అంటారు దాన్ని. Actuary అనేది a person who fixes the premium. Okay? Say yes.
Yes, sir.
Very
Yes,
good.
sir.
Yes, sir.
Now let us see the relationship between the partners and the other partners. It is like a principal and agent. It is like the same. The vicarious liability will be held liable over there. And let us see the Hamlin versus Houston and Company. One of the two partners of the defendant's firm, acting within the general scope of his authority as a partner, bribed the plaintiff's clerk and induced him to make a breach of a contract with his employer, plaintiff, by divulging the secret relating to his employer's business. It was held that both the partners of the firm were held liable for this wrongful act, inducing a breach of a contract committed by only one of them. మీకు ఎంత అర్థమైందో తెలియదు నాకు ఇప్పుడు. Now let us see that. I will give you an explanation. Both the partners ఉండండి. మనం టెండర్ వేస్తారు తెలుసా అండి మీకు? టెండర్
Yes, sir.
టెండర్ అందులో
sir.
ఒక్క పైసా కూడా తక్కువ వేస్తే మీకు వచ్చేస్తుంది టెండర్. ఆ ఒక్క పైసా ఎంత వేసిందనంటే అదర్ పార్ట్నర్ దగ్గర, అదర్ ఫర్మ్ దగ్గర పోయి ఒక పార్ట్నర్ వానికి బ్రైబ్ ఇచ్చి, ఎవరికి క్లర్క్ బ్రైబ్ ఇచ్చి, అరే ఈ ఫిగర్ చెప్పురా, వాడి ఫిగర్ చెప్పిండు, ఒక్క పైసా తక్కువ వస్తే వీళ్ళు టెండర్ వేసేస్తారు. But later on, it came to know that this fellow is leaked it. So they filed an action against inducing my employee for getting the secret of my tender. So if one partner did it, all the partners are held liable to pay the compensation. Is it clear?
Yes, sir.
కోకో
Yes, sir.
కంపెనీ ఉన్నది, ఇప్పుడు ఫాంటా ఉన్నది, ఏదైనా వాళ్ళ కాంపోజిషన్ ఎవరికి చెప్పరు. ఆర్ యు ఫాలోయింగ్ మీ?
Yes, sir.
Yes, that is a very trade secret. So they don't reveal to anybody. Only one man knows, and he will make it, and he will give the sample, and he will run the show. So in this way that we can make it the vicarious liability. But master and servant. In master and servant, again, there are two things will come. One is qui fecit, parilium fecit per se. Another is respondent superior. For the servant's activity, master is held liable for all acts, not criminal acts, but only some criminal acts where he authorizes it or where it is an essential. Bouncer అంటే తెలుసా అండి మీకు?
Sir?
బౌన్సర్
తెలుసు సార్, సెక్యూరిటీ గార్డ్ లాగా ఉంటాడు ఎవరైనా విఐపీస్ కి.
మీరు పబ్కి పోయినారు అనుకోండి, అక్కడ బౌన్సర్ ఉంటాడు ఒకడు.
అవును సార్, పబ్ లో ఉంటాడు.
ఏం చేస్తాడండి బౌన్సర్? బౌన్సర్ పని ఏంటి?
అన్ఆథరైజ్ పీపుల్ ని ఎంట్రీ ఇవ్వనివ్వడు సార్.
అనాథరైజ్ కాదు, ఒక రౌండ్కి రెండో రౌండ్కి ఏం తిరుగుతాడు వాడు, ఏమవుతాడు? ఫాక్స్ పోయి లయన్ అవుతాడు. ఏమవుతాడు? ఫాక్స్ పోయి ఏమవుతాడు? లయన్. లయన్ ఎందుకు? మందు తాగిన తర్వాత ఆ బౌన్సర్ ఏం చేస్తాడు? ఇట్ట చేతుని లేపి పక్క పడతాడు. వాడు ఎగు సిలక కొయ్యికి పెడతాడు. విన్నారా అండి?
Sir.
విన్నారా అండి? Bouncer got injured over there because his duty is to keep the calm. Suppose that fellow creates a nuisance, he will just give a small blow that is enough for him, and that is he is appointed for that purpose. So for his activity, manager or the owner is held liable. Bouncer duty adi kadandi. Are you following me? Yes anandi.
Yes, sir.
అది అనాలి అట్లా. తందానే తానే నేను ముందుగా నడుస్తా. ఇంకొక మీనింగ్ ఏంటి ఇదండి బౌన్సర్ అంటే? బాల్ బౌన్స్ అవుతుందా కాదా?
క్రికెట్
క్రికెట్ బాల్ బౌన్స్ అవుతుందా కాదా?
అయితే సార్.
అంటే తల మీదకి వెళ్ళిపోయింది అన్నట్టు అర్థం. ఇంకొకటి మీనింగ్, మీకు ఎప్పుడైనా తల మీదకి వెళ్ళిపోయింది అనుకోండి, నాకు అనండి, ఏమనండి? సార్ బౌన్సర్ అనండి. ఏమంటారండి? ఏమంటారండి? సపోజ్ సంథింగ్ యూ డిడ్ నాట్ అండర్స్టాండ్, మీ తలకాయ మీదకి వెళ్ళిపోయింది అనుకోండి, నా సెంటెన్స్ కానీ నా వాడు కానీ, సార్ బౌన్సర్ అనండి. నేను రిపీట్ చేస్తా దాన్ని. ఓకే?
ఓకే సార్.
రైట్.
Okay, sir.
సో నౌ లెట్ us see how it బి గోవిందరాజులు వర్సెస్ ఎమ్మెల్యే గోవిందరాజ ముదలియార్ కేసులా. ఆఫ్టర్ ది మోటార్ లారీ was interested by its owner for repairs, while employees of the repair workshop drove it, there was an accident. It was held by the Madras High Court that for this accident, the owner of the lorry was not liable vicariously because the owner of the workshop was an independent contractor and not the servants of the lorry owner. ఏమైనా అర్థమైందా అండి మీకు? సార్ మీరు ఇంత స్పీడ్గా చదివింది సార్, మాకేం అర్థమవుతుంది సార్?
Yes, sir. Independent contractor.
Actually,
So is not held liable.
గ్యారేజ్ అంటే తెలుసా? గ్యారేజ్
Yes, sir.
రెండు మీనింగ్ వస్తుంది.
Repairing
గ్యారేజ్ అంటే ఈ ఆటోలు పెట్టేదే కాదు, 3 వీలర్స్ వేర్ ద రిపేర్స్ ఆర్ గోయింగ్ ఆన్. దాన్ని ఎవరైనా వరంగల్ ఉన్నారు అనుకోండి, వరంగల్ ఉన్నారనుకో, ఆటో నగర్ అది రిపేర్ షాప్, ఆటో నగర్, వేర్ ద వెహికల్స్ ఆర్ రిపేర్డ్ ఓవర్ దేర్ ఇన్ ఆటో నగర్. అయితే వీడు ఏం చేసిండు? బండిని లారీని ఆటో నగర్లో ఇచ్చేసిండు. ఏది ఇంట్రెస్ట్కి, గ్యారేజ్కి. వాడేం చేసిండు? బండిని నడిపిండు. తర్వాత ట్రయల్కి పోతారు చూడండి, ట్రయల్కి పోయినప్పుడు గుద్దిండు. ఎవరు గుద్దిండు? ఆటో గ్యారేజ్ ఎంప్లాయీ గుద్దిండు. అప్పుడు ఓనర్ ఈజ్ హెల్డ్ లయబుల్ వికారియస్లీ హియర్?
No, sir.
Answer no, because The vehicle is given to the garage. The garage owner is the owner of the vehicle for the time being. And the employee of the garage has met with an accident. At that instance, the owner of the garage would be held responsible, but not the owner of the vehicle. Generally, మళ్ళీ ఇక్కడ కూడా ఏమవుతుందండి, ఇన్సూరెన్స్ ఉన్నదనుకోండి, ఫస్ట్ ఇన్సూరెన్స్ కంపెనీ షుడ్ హావ్ టు పే. ఆర్ యు ఫాలోయింగ్ మీ?
Yes, sir.
Yeah, that is again the thing will come over there. So now let us see the other decided cases, vicarious liability. That is the Devinder Singh versus Mangal Singh. Yes, can anybody will unmute and read this case law?
In Devinder Singh versus Mangal Singh, in that case, Devinder Singh entrusted his truck for repairs to a workshop. While the truck was being driven by the owner of the workshop, there was an accident which resulted in injuries to a cyclist, Mangal Singh. In an action by the injured cyclist against the owner of the truck, it was held that the owner of the workshop was an independent contractor and not the servant of the owner of the truck, and therefore the owner of the truck would not be made vicariously liable for negligence of the owner of the workshop.
Same, nothing changed. Only the case law name is changed. It is given to the garage. The garage man repaired it and went for the trial and collided, made an accident with a cyclist. What is the cyclist's name?
Mangal Singh.
Mangal Singh. The person who committed maybe the Devinder Singh or the owner of the garage, doesn't matter. Then whether vicarious liability will be applicable over here?
No.
Yes, sir, applicable.
No. ఇంతసేపు అనండి
Not
ఆలోచించిన.
applicable.
నేను చెప్పడం ఆగిపోయిన ముందటే రావాలా ఆన్సర్ మీ దగ్గరికి వెళ్ళి. Because
He's an independent contractor.
he is an independent contractor. That is, the independent contractor himself is liable. Because the independent contractor is not under the control of the master. Independent contractor is not under the direction of the master. The independent contractor is a skilled person and he doesn't need any direction from the owner. Hence, whatever the employees are working over there, either he did it or the employee did it, at that instance, he will be held responsible, but not the owner of the vehicle. But in all the cases, who will come to the rescue of the victim? Who will come
Insurance
to the rescue?
company.
Insurance company. Then insurance company కి ఏమంటారు? ఇన్సూర్డ్ అంటారా అండి, ఇన్సూరర్ అంటారా?
Insurer.
ఇన్సూరర్ అంటారు. ఇన్సూర్డ్ అంటే సబ్జెక్ట్ మ్యాటర్, పాలసీ హోల్డర్ని. Okay, the trend of the recent decision of the various high courts to allow the compensation to the accident victims against the owner of the vehicle and through him the insurance company. ఇందాక చెప్పాను చూడండి, ఇన్సూరెన్స్ కంపెనీ will come to the rescue of the person. The concept of the principal agent relationship and the liability of the farmer that is explained with the Bombay High Court in the again the another case law also, Ramu Tularam versus Amichan. Whenever the act is done under the independent contractor, at the time the owner is not liable, only independent contractor to be held liable because there is no vicarious liability in such a case. Kani. In the strict liability, even though the work is done by the independent contractor, the owner is liable. What is the name of the case law? The classical case law we discussed several times. Hint ఇస్తాను నేను. Mines, shaft, incline, open cast. What is the name of the case law? Sump gave the way, total water filled with the mine. The sump is constructed by the independent contractor, but still the owner is held liable under the strict liability. What is the name of the case law?
Pass on, sir.
Rayland versus Fletcher. RYLAN. Rayland versus Fletcher. FLETCHER. That is the case law. Okay. So now let us see the apex court in the National Insurance Company Limited versus Mastan, going by the principle of the election observed on the language of the section 167 of the Motor Vehicle Act and going by the principle of election remedies as a claimant opting to proceed under the Workman Compensation Act cannot take the recourse to draw the inspiration from any other provision of the Motor Vehicle Act of 1988 other than what is specifically saved in the Section 167 of the Act. Section 167 of the Act gives the claimant, even under the Workman Compensation Act, right to invoke the provision of the Chapter 10 of the Motor Vehicle Act of 1988. Chapter 10 of the Motor Vehicle Act 1988 deals with what is known as the no-fault liability in case of an accident. So wrong done as a natural consequence of an act by the servant by the master of the due care. You cannot get the claim from both the sections, both the acts. Either you can go for the Workman Compensation Act for getting the compensation, or you can go under the negligence under the Motor Vehicle Act. But you cannot, for the same cause of action, two remedies are not available. You can tap only one remedy. అయితే ఇందులో పైసలు ఎక్కువ వస్తాయండి. ఎస్,
ఇన్సూరెన్స్
వర్క్మ్యాన్ కాంపెన్సేషన్ యాక్ట్లో ఎక్కువ వస్తాయా పైసలు, లేకుంటే మోటార్ వెహికల్ యాక్ట్ అందులో వస్తే పైసలు ఎక్కువ వస్తాయా విక్టిమ్కి? చెప్పేసేయండి సార్, నేనే చెప్తా కదా. వర్క్మ్యాన్ కాంపెన్సేషన్ క్యాప్ అంటారు, అంటే సీలింగ్ ఉంటుంది దాంట్లో. ఓకే, కాలు ఇరిగింది ఇంత ఇయ్యాలా, చేయి ఇరిగింది ఇంత ఇయ్యాలా, బొటవెన ఇరిగింది ఇంత ఇయ్యాలా. కాలు బొటవెనెల్లో ఏమంటారండి? ద బిగ్ టో ఆఫ్ లెగ్ ఈస్ కాల్డ్
హలాక్స్ సార్.
హలాక్స్. ఎందుకు అడుగుతానంటే మెమొరీ ఉన్నదా లేదా అని అడుగుతాను నేను. ఎందుకంటే ఐ టోల్డ్ యూ ఆల్రెడీ, HALUX హలాక్స్, బొటవెనెలు. ద లెగ్ బిగ్ టో ఈస్ కాల్డ్ హలాక్స్. Halax compensation is more, but a fixed amount would be there in the Workman Compensation Act. But if you apply a good lawyer, very versatile and having the 360-degree angle thinking, and that fellow will make the many slots of the damages over there. The claim in the damages are more when you come to the compare with the Workman Compensation damages. దాన్ని ఏమంటారు? వర్క్మ్యాన్ కాంపెన్సేషన్లో క్యాప్ అంటారు. క్యాప్ అంటే సీలింగ్ ఉంటుంది, కానీ బట్ ది మోటార్ వెహికల్ యాక్ట్లో స్లాట్స్ ఎన్నో ఉంటాయి. ఆ స్లాట్స్లో that fellow will make it out, because the age will take and how much he will remuneration he will make it out, how much at the time of the accident and how many dependents are there. So everything they will calculate it, and the different slots they will make it out, and hence the compensation is more under the Motor Vehicle Act. So under the negligence. So now Grigori versus Piper case law, let us see that case law. The defendant and the plaintiff had some disputes between them, and the defendant therefore ordered his servant to place a rubbish across the pathway to prevent the plaintiff from the proceeding on that way, and the servant took all the care to ensure that no part of us was touching the part of the plaintiff's property. But in the passage of some time, the rubbish slid down and the touched the walls of the plaintiff, and thus he sued for the trespass. The defendant was held liable despite his servant taking all the due care. వాడు దారిని పోతాడని ఏం చేస్తున్నట్టే, హీ వాంట్స్ టు కట్టేల్ ద దారి, సో ఆల్ ద రబ్బిష్ హీ పుట్ ఇట్ ఓవర్ దేర్, సో దట్ ద అదర్ ఫెలో కుడ్ నాట్ యూజ్ హిస్ ల్యాండ్ అండ్ గో ఫ్రమ్ హిస్ హౌస్ ఫర్ ద షార్ట్ రూట్. But this rubbish, what he put it over there after the due time of because of the air, it is slowly slided down and touched the wall of the plaintiff. When it touched the wall of the plaintiff filed a case against the defendant. Can he, that the defendant is liable or not?
Liable, sir.
Liable, because the rubbish touched the plaintiff land, means trespass to the property. Either you pass on or any other thing pass on, it is enough. It's a trespass to the property. Hence, he will file a case, even though the due care is taken by the defendant's servant to keep the rubbish not to slide over to the wall. Because of the wind, because of the other factors, it slowly slid down and it touched the wall. It is amount to the trespass. Hence, even though you have taken the due care, but still the vicarious liability is liable. So that is the case law where we can make it. Wrong due to the negligence of workers. Yes. Another case law. The Pushpa by Purushottam Odeshi and other versus Ranjit Ginning and Pressing Company, Private Limited. Deceased was traveling in a car driven by the manager of the respondent company, and it met with an accident, as a result of which he died. The dependent of the deceased filed a claim at the tribunal, allowed the damages on the appeal to the High Court. It was set aside on the grounds that the accident does not make a respondent company liable, but the Supreme Court in its judgment overruled the judgment of the High Court and held that the From the facts of the case, it was clear that the accident has occurred due to the negligence of the manager who was driving the vehicle in the course of his employment, and therefore the respondent company was liable for his negligent act. ఏమన్నా అర్థమైందా అండి? మాష్కి ఏమన్నంత అర్థమైందా అండి?
No, sir.
ఇప్పుడు I will give you in simple words. See, the vehicle is belong to a particular company, and the vehicle is driven by a manager. So one of the employee of that company, he asked for the lift, and the manager has given the lift. When he was driving, the manager met with an accident where this employee got injured, and he filed a case against the vicarious liability to the company, because manager is also employee and he also an employee. But the manager's negligence met with an accident, so vicarious liability would be liable. సార్ మీరు లిఫ్ట్ అన్నారు కాదు సార్, మరి లిఫ్ట్ తీసుకుంటే అక్కడ వాలంటీ నాట్ ఫిట్ ఇంజరీ వస్తుంది కాదు సార్. పద్మావతి వర్సెస్ దుగ్గనాయక. A stranger who got the lift means he has given the consent. Voluntary not fit injury. At the time, he is not going to get anything. But here the case is, he is one of the employee of the same company. He is not a stranger. Are you following me?
Yes, sir.
Yes, sir.
He is an employee
Yes,
of the
sir.
same company where the manager is working and where this employee is also working. The manager gave the lift for the employee, and at the time met with an accident. That means it is done in the course of the
Employment.
employment. Hence, the company would be held liable. So, if H works as a house cleaner for K, then there is a master and servant relationship between them. But if H, instead of cleaning the house, decides to cook food, even though he was only hired for the cleaning the house, and due to his negligence causes a fire, which also causes loss to the case neighbor L, then K will not be liable because he did not act, and he was outside the course of his employment. ఇప్పుడు చెప్పండి సార్, if a person is employed to clean the house, I repeat, if a person is employed to clean the house, ఈ క్లీన్ ద హౌస్ని, ఈ మాల్ క్లీనర్ని ఏమంటారండి? నేను చెప్పాను మిస్ఫీజన్స్, నాన్ ఫీజన్స్, మాల్ ఫీజన్స్ చెప్పేటప్పుడు చెప్పాను. సూపర్ మార్కెట్లో ఆమె ఫోటో వేసి చేతిలో మాప్ ఉంటుంది, ఆమె క్లీన్ చేస్తూ ఉంటుంది, వాళ్ళని ఏమంటారండి?
Janitor, sir.
Janitor. I appreciate. Janitor. So the janitor, instead of janiting work, she's cooking. And when he was cooking, a fire accident occurred over there. Because of the fire accident, the neighbor's house was burnt. Is there vicarious liability applicable over here? Yes?
Yes, sir.
No. Because her duty is to only to the clean it, but she was cooking. Instead of, and she have been hired for the cleaning the house, and due to his negligence causes a fire which also causes a loss to the case neighbor L, then K will not be liable because he did not act which was outside the course of his employment. Who did not act? Janitor will not
K.
act. What is the janitor duty?
Cleaning the
Duty.
house.
Why she is cooking for that purpose?
Because the master has requested it.
If master requested, then it's okay. But without the knowledge of the master, if she cooked it, then naturally at the time vicarious liability will not be there. But generally we will say without master consent, how she cooks. That means if the implied consent would be there, she is cooking, and hence a master should be held liable. But when it strictly says that I never used her for the cooking because I have the another a lady or man would be there for the cooking purpose. At that instance, if you cook it, నేను చెప్పాను చూడండి, ఫైర్ స్టేషన్లో ఏమన్నాను, if the fire brigade reaches over there and if you go and there you will call a trespasser. But if the fire brigade is not there but you went over there, you are not a trespasser. సార్ చెప్పారు కానీ సార్ గుర్తులేదు సార్. కేసులో హోప్ వర్సెస్ షార్పరా సార్, కేసులో థామస్ వర్సెస్ ఒక్కటే గుర్తున్నది సార్, ఏదేది గుర్తులేదు సార్. గుర్తుపెట్టుకోవాలా, మస్ట్ రిపీట్ చేయాలా. రాత్రి 12 గంటలకు కూడా లేపి, అరే చెప్పురా బాబు, ఫైర్ బ్రిగేడ్ వాడు పోయిందనుకోండి, అప్పుడు ట్రెస్ పాసర్ అవుతారా అంటే వాడు ట్రెస్ పాసర్ కూడా అవుతాడు, నేమ్ ఆఫ్ ది కేసులో కూడా చెప్పేసారు. ఆర్ యు ఫాలోయింగ్ మీ?
Yes, sir.
Yes, that is the spirit. You develop it. That comes only by the repetition. So wrong by excess or mistake excuse of the lawful authority for making the master liable in such a case. It has been shown that suppose master has consented to it, okay, no matter. Vicarious liability. So ఇక్కడ Bailey versus Manchester S and Railway Company, a porter of a railway company while working mistakenly believed that the plaintiff was in the wrong carriage even though he was in the right one. The porter thus pulled the plaintiff, as a result of which the plaintiff sustained the injuries. Here the court held that the railway company vicariously liable for the act of the porter because it was done in the course of his employment, and his act would have been proper if the plaintiff was indeed in the wrong carriage. అర్థమైందండి ఏమన్నా? ఇది రైల్వే పోర్టర్ ఒక ప్యాసింజరు రాంగ్ ట్రైన్లో కూర్చున్నాడని వాడిని గుంజేసి కింద పట్టేసిండు, వాడు ఇంజూర్డ్ అయిండు. ఏ పోర్టర్ ఈజ్ హ్యావింగ్ సచ్ ఏ వర్క్ టు డూ. ఏ పోర్టర్ డ్యూటీ ఈజ్ భక్తులారా,
I have to carry the luggage.
టు క్యారీ ద గూడ్స్, లగేజ్ క్యారీ చేయడం. రాంగ్ ట్రైన్లో పెట్టాను అని గుంజి కింద పెట్టేది అనుకోండి, ఈవెన్ దో హీ డిడ్ ఇట్ మోర్ దెన్ వాట్ హీ సపోజ్ టు డూ, బట్ స్టిల్ ఇట్ ఈస్ సే దట్ ఇట్ ఈస్ ద కోర్స్ ఆఫ్ ది ఎంప్లాయ్మెంట్. హెన్స్ రైల్వే ఈజ్
Held liable.
లయబుల్ అండర్
Vicarious liability.
అదే కేసులన్నీ ఒకసారి చెప్పాను నేను. రైల్స్ అన్నాను, స్లీపర్స్ అన్నాను, స్కేల్స్ అన్నాను, ఆడామె నిలబడ్డదన్నాను, ద స్కేల్స్ కేమన్నాను. ఇద్దరు రైల్వే గార్డు, వన్ ఈజ్ ఇన్ ద bogie, అనదర్ ఈజ్ ఇన్ ద ప్లాట్ఫామ్. హీ ట్రై టు పుష్ ద అనదర్ పర్సన్, బట్ ద ఏ wrapped a 15 centimeters wrapped newspaper wrapped a packet fell down on the tracks. It is exploded over there because it's a cracking material. And the scale come and injured the plaintiff, and the plaintiff whether he could get it or not. ఏంటిదండి నేమ్ ఆఫ్ ది కేస్ లాది?
Pass answer.
పాల్స్ గ్రాఫ్ వర్సెస్ సౌత్ లండన్ రైల్వే కంపెనీ లిమిటెడ్. ఐలాండ్ సౌత్ ఐలాండ్ రైల్వే కంపెనీ. సరే, ఇక సౌత్ ఐలాండ్ రైల్వే కంపెనీ, యూ షుడ్ నాట్ షో యువర్ ఇగ్నోరెన్స్ టు ద ఎగ్జామినర్. పాల్స్ గ్రాఫ్, అది ఎవరు? హెలెన్ పాల్స్ గ్రాఫ్. షీఈ్ ద లేడీ. మిస్సెస్ హెలెన్ పాల్స్ గ్రాఫ్ కేసులా ఏం ప్రిన్సిపల్ ఉన్నదండి అక్కడ? ఇఫ్ ద రిమోట్ ఈస్ దేర్, టూ రిమోట్ ఈస్ దేర్, షీ ఈస్ నాట్ గోయింగ్ టు గెట్ ఇట్. నెంబర్ 1. Number 2, there is no duty of care towards the plaintiff. Number 2, remoteness is there. Number 3, possibility is there. One cannot make it possible in such a way. So the railway company is not liable in that regard. But here, railway companies
liable.
Vicariously
Vicariously
Yes, Anita
liable.
Bhandari and others versus Union of India. The husband of the petitioner went bank, and while entering inside, the cash box of the bank was also being carried inside. As a result, the security guard in a haste shot him and caused his death. The petitioner had claimed the bank was vicariously liable for the case because the security guard had done such an act in the course of the employment, but the bank had contended that it had not authorized the guard to shoot. The court held that the bank liable as act of the giving a gun amounted to authorize him to shoot when they deemed it is necessary, that while the guard had acted over jealously in his duty, but it was still done in the course of the employment. పాపం వీడు కస్టమర్ ఏం చేసిండండి? అకౌంట్ హోల్డర్ బ్యాంకు పోయిండు. బ్యాంకు పోయి ఏం చేసిండు? బాగా పైసలు తీసుకుంటప్పుడు వాళ్ళు ఒకటి కనిష్టం ఒక బ్యాగ్ పట్టుకెళ్తారు, బాక్స్ పట్టుకెళ్తారు, క్యాష్ బాక్స్. ఆ క్యాష్ బాక్స్ వేసుకుని వస్తాడు. అయితే వీడేమనుకున్నాడు, ఎవరు? సెక్యూరిటీ గార్డు. వాడు బ్యాంక్ దోచుకుని వస్తాడని ఏం చేసిండు?
కన్నదోడు కాల్సిండు,
షూట్ చేసి పడేసిండు. వాడు అక్కడికక్కడ స్పాట్లో చచ్చిపోయిండు. Without applying the brain that God has made it, and he shoot that man. Actually, he's draw the amount and he getting in the cash box. జీతాలప్పుడు ఏం చేస్తారంటే క్యాష్ బ్యాగ్లా తీసుకొస్తారు, లారీ తీసుకెళ్ళి. అది ఫనీ. అదే వెహికల్ విల్ టేక్ ఇట్ అండ్ ఏ సేఫ్టీ లాకర్ వుడ్ బి దేర్, దే విల్ క్యారీ ఇట్ బికాస్ ద హెవీ అమౌంట్ వుడ్ బి దేర్. ఇప్పుడు మనం ఏటీఎంలో ఏ దానికి తెలుసా అండి? సెక్యూరిటీ గార్డ్ వస్తాడు, చూసిండ్రా? మన దగ్గర గన్ ఉంటుంది.
Yes, sir.
సో Why the gun is given? Sir, gun is given. చిరగొని ఆడదానికా అండి గన్ను, లేకుంటే కోలాటం ఆడదానికా గన్ను? For shoot it if any untoward incident is going to happen.
safeguard money.
So here the bank is held liable to pay the compensation because it's done in the course of the employment. It is not the ultra virus act, because he thought that this fellow is stealing and carrying it, but actually he is draw the amount and he is going over there. So bank is liable. So Olympus and London General Omnibus Company, the driver of the defendant company, willfully and against the express order not to get involved in a racing or obstruct their omnibus, has driven to obstruct the omnibus of the plaintiff. In the case, the court held that the defendant company was liable for the act of the driver because the driver act of driving in the omnibus was within the scope of the course of the employment. If it does anything for the bus, if it driven improperly, then the owner is held liable. Are you following me? Sir,
Yes, sir.
కండక్టర్ ఏం చేసిందంటే, నేను నెక్స్ట్ టర్న్కి కండక్టర్ ఏం చేసిందంటే నెక్స్ట్ టర్న్ తీసుకొని తిప్పుకుంటా వచ్చి పెడదామంటే యాక్సిడెంట్ చేసి పడేసిండు. వైకారస్ లయబిలిటీ అవుతుంది అంటే అక్కడ వాట్ ఈస్ ద డ్యూటీ ఆఫ్ ఏ కండక్టర్? టు ఇష్యూ ద టికెట్స్. బట్ వై హీ టర్న్ ఇట్? సార్ రోజు టర్న్ చేస్తాడు సార్, అది ఇవాళ కూడా టర్న్ చేసిండు. Whether the driver is having the knowledge? If the driver is having the knowledge, if the driver has given the permission, yes, vicarious liability would be there. But the driver says, no sir, I did not know that fellow, when I came over there, that he turned it and he made it with an accident. Then vicarious liability will not be applicable over there, because he done the act, overact, extra, power kana ekkuva chesindu. So sometimes it is held liable, sometimes it is not liable. So these are the cases would be there. And where, let us see the Peterson versus Royal Oak Hotels Limited. The plaintiff was a customer who was on being intoxicated was refused to further drinks by the barman who was employed under the respondent, and thus the plaintiff threw a glass at him. The barman took a piece of the glass and threw at him, which hits his eye. The respondent hotel was held liable to due to the act of the barman who had a master servant relationship with him. ఏమర్థమైందండి చెప్పండి, చూసుకుంటే చెప్పండి, ఎక్స్ప్లెయిన్ చేయండి నాకు. ప్లేంటిఫ్ ఎవరండి? కస్టమర్. ఎక్కడ పోయిండండి? తాగదానికి పోయిండు. ఎక్కడ? బార్లో పోయిండు. ఆ తర్వాత ఏమైందండి? రెస్పాండెంట్ ఎంప్లాయిడ్ ఏం చేసిండండి? సార్ మీరు ఆల్రెడీ తాగి ఉన్నారు కాబట్టి ఇంకా ఇయ్యలేవాడు, ఆల్రెడీ వాడు ఊగుతాడు. ఆ తర్వాత ఇచ్చిందనుకో వాడు ఫ్లాట్ అయిపోతాడు. మళ్ళీ అరే నువ్వు ఇయ్యవారా నాకని వాడు ఏం చేసిండు? గ్లాస్తో కొట్టిండు. ఎవరిని కొట్టిండు? అటెండర్ని కొట్టిండు. అదే బార్మ్యాన్. వాళ్ళని ఏమంటారండి? స్టీవార్డ్స్ అంటారా? అటెండెంట్ అంటారా? కొడితే వాడేం చేసిండు? ఆ ముక్క ఉన్నది కదా, ఏది గ్లాస్ బదిలిన ముక్క, వాడి ఇసిరేసిండు. ఇసిరేస్తే ఏమైందండి? తన్ను పోయింది. ఎవరిది పోయింది? కస్టమర్ది పోయింది. The respondent hotel was held liable to the act of the barman who had a master and servant relationship with him. ఎవరు held liable అండి?
Hotel.
Barman is held liable for the activity of the attendant, a steward, or waiter. Waiter ఏమో masculine gender, మరి feminine gender ఏంటిదండి? Yeah, it is the Indian tradition that in the beginning or the ending of any program that we will make the play of the national anthem. Now the national anthem will be. Jana Gana Mana Adhinayaka Jaya He Bharat Bhagya Vidhata Punjab Sindhu Gujarat
विन्ध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
जय हिंद।